All right, the court will call the case of the state of Michigan versus Eric Martin, case number 23S00425.
Rachel McDuffie for the people.
And standby counsel, Assistant Public Defender Jay Bellinger from Mr. Eric Martin, who appears via Zoom. Mr. Martin, can you please unmute and state your name for the record?
I'm a living man, capital E, lowercase R-I-C, of the capital M, lowercase A-R-T-I-N family. One of the people, sovereign, not a legal fiction corporate entity defendant with a name similar to mine. I'm here by special appearance to threaten duress, not willingly. Now, again, I object again to any attorney being appointed to me, representing me, but that's something I want to ask you, Washington. Now, you said you're appointing this public defender. Are you appointing it for me, or are you appointing it for you? Or is it just standby?
Decision on that is standby counsel. If you have motions to make, you need to make those at this time.
Yeah, that's I need. I'm seeking clarification. Are you appointing him against my will to have an attorney appointed for me?
Yes, it's not representing you. He's standby counsel. Please make your motions.
Okay, that's it. Well, that's I was going to make the motion to dismiss him if you're trying to appoint him for me, which, as I already said before, I will not be taking no attorneys. I'm one of the people. I'm not a defendant so as I said before. So I'm not going to be accepting any attorneys.
And to be clear, no one is forcing him to accept the attorney, but the judge is doing what is required to protect his constitutional rights by appointing standby counsel. That way, if he suddenly realizes he is in over his head, there is someone available who actually understands the legal system and can step in to help guide the process. It is basically a safety net because representing yourself in a serious case can go wrong very quickly if you do not know what you are doing. This approach gives him the freedom to proceed on his own while still ensuring that he has access to proper legal support if he chooses to use it later.
Fraudulently assume I'm a defendant, and which would then fraudulently give the presumption I'm under the jurisdiction of the court, which I'm not. As I said before,
you got 5 minutes to make your arguments, and you can spend them however you want to.
All right, yeah. Like I said before, I'm a living man, so as the U.S. Supreme Court said in the cases I cited to you before, there's no jurisdiction over a living man. Corporations don't have jurisdiction over a living man without our consent. I don't consent. And it's also under, there's no consent under the Declaration of Independence of 1776. There's no jurisdiction over a human without their consent. So I never consented to jurisdiction, and I don't now, and I never will. Now I have some questions, though, for the prosecutor.
Sir, you don't get to ask questions. If you want to have a motion, you can make those.
Well, I object to that. That violates my right to a due process. It's relevant to a standing argument as to the prosecutor, whether they have standing or not. I think that's relevant to move forward or not, There's no standing, shouldn't move forward, but... So what's your ruling on that?
Your motion is denied as to jurisdiction and standing. Now, do you have any additional motions?
I object to that because you didn't allow me to answer the questions to see whether you had a legit basis to make that ruling.
Your objection is noted. Next.
Judge Washington is clearly not entertaining any of this nonsense, and she is keeping things moving without letting the situation spiral into chaos. She has no time for distractions or pointless arguments, and it shows in how firmly she handles the courtroom. You can tell she is focused on maintaining order and making sure the process stays on track rather than letting it turn into a circus. Her presence alone sets the tone that this is a serious proceeding and not a place for games or attention-seeking behavior.
You say you're going to be questioning me about the some demands I made to dismiss the case anyway, right?
I'm sorry, what?
You said you're going to be addressing some demands for dismissal I made or sent to you already.
So first of all, a demand is not a proper format before a court and could be dismissed outright. However, I'm going to allow you to make your motions here. If you want to make an argument, you can do that, sir.
Okay, I object to that. That's not true. As I mentioned before, demands, when someone has the right to something, that's what the terminology demand is made. And that's the only reason why I make it. Motions, even though I know that's all you see in the court rules or whatever, traditional. But that's for a request, and persons or humans are not supposed to be requesting constitutional rights. You know, me exercising my unalienable right, human rights and constitutional rights, I'm supposed to be making demands. That's how I've been, you know, and that's backed up by law. That's how I've been taught. And so that's what, you know, so it's all right and proper. Motions are requests, you know. And the defendant makes motions also, since I'm just.
So you're about the end of your 5 minutes.
Well, I objected 5 minutes being any time limit also.
I don't care about what you're objecting to. You can make it on the record. It is noted. Now, if you have something that you want me to address, you should do that before your time is up.
Putting a limit on my First Amendment right, that's unconstitutional.
Sir, please, if you want to have something to say other than the circular talk that you're doing, you should probably do that at this time.
I didn't finish. That's why I didn't mean to. No, none circular. I didn't finish the first time. All right. Well, that's it. As to that,
Is the court ready for the people's response run?
I don't know if he's done with his motion.
Oh, I'm sorry.
I'm trying to make.
Well, the police. I wanted to question the police officer who wrote the ticket. I have a relevant question to him as to self-incrimination. Move to dismiss the case based on that, because he made me give, you know, my ID.
I get the point you are making here, but it is based on a misunderstanding of how authority actually works in the legal system. A private individual does not have the same powers as a police officer because law enforcement is granted specific authority by law to conduct stops and request identification under certain circumstances. That authority does not come from personal opinion or belief, but from statutes and established legal standards that courts recognize and enforce. So even if someone claims that police have no jurisdiction, the reality is that the law does give officers defined powers that ordinary citizens do not have. Refusing to comply based on personal theories usually leads to more legal trouble rather than solving anything. In practice, the system operates on established rules, not on whether someone personally accepts those rules or not.
But my memory was a little, I don't really remember exactly what was said. That's why I kind of need to question him to refresh the memory. But I do remember in general, though, he kind of, you know, I'm required to give my ID if I remember right, and I might have been arrested if I didn't give my ID, which was under threatened arrest. And even if he didn't say that, which I don't remember, which, like I said, I need to have his body cam and all that. I want to be able to review that. Now, and also for the trial, if this goes to trial, I want the video present as part of my due process right for the evidence, which is my due process right, like I'm saying. And because, like I said, it violates my self-incrimination right, that I'm being made to give my supposed name, government name anyways, which ain't really my name, but a government name has been given. Violates self-incrimination, and then it's used against me to prosecute. So it violates self-incrimination. Move to dismiss based on that too. And like I said, if you need more evidence as to, like I said, his questions, then he needs to answer my question. I was about to send out interrogatories to him. I'm about to do it here soon. If you find that's necessary, unless you find it ain't necessary, I'm gonna send it out soon. So, another thing. Now, Mrs. Washington, I just filed a federal civil lawsuit on you for violating my constitutional rights during this case. So you may want to consider recusing yourself. I know you probably didn't get a receipt yet because I just sent it out like 2 days ago. So the court will be getting it, if they didn't get it already, be getting it this week. And yeah, so I want that out.
As to your motion to recuse, that is denied.
Based on what reason?
The reality here is that simply demanding a judge step aside does not make it happen because there has to be a valid legal reason to justify recusal. Courts look for clear evidence of bias, conflict of interest, or some specific issue that would prevent a fair hearing. If none of that is presented, then the request is going to be denied every time. It works the same way with a public defender because you can ask for a different attorney, but the court is not required to grant that request unless there is a legitimate problem with representation. Just being unhappy or disagreeing with how things are going is not enough. The end of the day, the legal system runs on established standards, not personal frustration, so without a solid argument backed by real facts, these kinds of requests are not going anywhere. School. At that point, he really did himself no favors because statements made in court can absolutely be used against him, and if he effectively admitted guilt on the record, that can seriously impact how the case moves forward. Courts do not just ignore something like that, and it can remove the need to prove certain elements since he already said it himself. This is exactly why having proper legal guidance matters, because knowing when to speak and what not to say can make a huge difference. One careless statement can end up doing more damage than anything the prosecution might have presented.
I didn't mention that, but I thought you might kind of already figured that. But conflict of interest due to the lawsuit being filed, that's the grounds of my demand for dismissal.
Okie dokie.
And I would like to, Ms. Duffy, as the prosecutor, I'd like to notify you, of the crimes being committed against me by the police officer, in this case, writing the tickets, and I request you prosecute them for this, because I'm the crime victim here in reality. Because I was traveling by right, which the U.S. Supreme Court said we have, as long as you're not carrying passengers probably for profit, you're not technically driving a motor vehicle. Therefore, all these charges are baseless. There's no case here. So in reality, I was harassed, retaliated against for exercising my right to travel on my motorcycle, and then with these charges. Okay, so they had no evidence that I was carrying passenger property for profit, which is what's required. That's the definition of a motor vehicle under 18 U.S.C. section 31 subsection 6 and 10. That's when a motor vehicle is a motor vehicle. In contrast to the state law, I know what the state law says. The state law just says, if something's mechanically drawn, it's a motor vehicle. Well, the state statute is in violation of this federal statute. Therefore, it's unconstitutional. Okay, and therefore, the federal statute definition of motor vehicle applies here. It overrides the state statute under Article 6 of the U.S. Constitution. Laws of the United States is supreme over state law. So therefore, I wasn't doing anything wrong. I was traveling by right on my motorcycle, as I have a right to do, without a license, without registration, without insurance.
It really makes no sense to keep escalating it like that, especially when there is no indication that the situation falls under anything the FBI would even handle. When an agency does not respond, it is often because the issue does not meet their criteria or lacks any real basis. Continuing to call them is not going to suddenly make it legitimate, and it definitely will not help your situation in court. That point, it comes across more like frustration than strategy, and it can actually hurt your credibility because it shows you are not focusing on the actual legal process in front of you. The smarter move would be to deal with the case through the proper channels and stick to arguments that are grounded in reality rather than trying to pull in outside agencies that have no role here.
So I was all within my right under that federal statute and the U.S. Supreme Court case law that I cited already in the court that they sent back. But one of the main cases here is Packard versus Banton, U.S. Supreme Court case law. Okay, this is a little more specific than just saying people have a right to travel. It mentions it specifically. And I'm going to mention right here, volume 44, Supreme Court Reporter, page 259. The streets belong to the public and are primarily for the use of the public in the ordinary way. Their use for the purposes of gain is special and extraordinary, and generally at least may be prohibited or conditioned as the legislator deems proper. As they're saying right there, so we do not need a license if we're not using the streets for profit, for gain. I wasn't doing that. The police don't have no evidence of that. So he shouldn't even pull me over, stop and wrote a ticket, none of that. So I'm the crime victim. I request you prosecute him for that. And it's also a federal crime, which I'm going to be contacting the FBI about. I already tried once. I got to call him back.
The reality here is that a courtroom is still a courtroom whether it is in person or over Zoom, and the same rules of conduct and procedure apply either way. Just because someone is behind a screen does not mean they can ignore instructions or treat it like a casual setting, because the court expects the same level of respect and order at all times. At this point, the focus shifts to the prosecutor, who is about to respond with arguments grounded in actual law and procedure, which is where these kinds of claims usually fall apart. When legal standards and facts are laid out clearly, it becomes very difficult for unsupported theories to hold up, and this is typically where the gap between belief and reality becomes obvious.
Anything else, Mr. Martin?
Well, I'm gonna see if you got my. If you're gonna, I would like to just reiterate my the demands for dismissal already made, or if you want to call them motions. But like I said, I like using the word demand because I want to. I don't agree to no unlawful presumptions that. Because I understand the legalese a little bit, where you say one word and it means something else, and it's presumed, and that's why I demand also that there be no legalese used in no stages of this case, because that's one of the fraudulent things going on in the court system. I'm gonna be filing a class action to stop this on a grand scale, but I know it's happening. That's why, like, for example, I use the word demand to use the word motion, and it can be presumed you're a defendant. Because defendants make motions, see? So that's why there should be no legalese used here. It's fraudulent, it's wrong, it's immoral, it's pathetic. Whoever made this stuff, because it's putting it's a blanket on a lot of people that don't know no better in the system. Something else. Now, when this proceeding started, I noticed on the screen it said no recordings are allowed. Okay, now I object to that, in that violates my due process right to preserve evidence, me or anyone else, and I'm not just speaking for me, I speak for everyone else. All the people have a right to record in any public court. This is all public. The U.S. Supreme Court already said this. People have the First Amendment right to record in public, anywhere. And it's also a due process right to preserve evidence. Because if my rights are violated during these proceedings or any other, along with anyone else's, we have the right to record that and have that evidence to bring criminal or civil charges. So that's why that's not supposed to be popping up on a screen that video, audio recordings ain't allowed.
He really picked the wrong moment and the wrong person to challenge, because this is one of those situations where the gap in knowledge becomes impossible to ignore. When someone trained in the law steps in and starts laying things out clearly, it quickly exposes how weak those arguments actually are. It is not about style or confidence at that point, it is about understanding procedure statutes and how courts actually operate. What makes it stand out is how calmly and professionally the response is delivered, because there is no need for theatrics when the law itself does the heavy lifting. It ends up being a sharp reminder that legal expertise is built over years of study and practice, and it is not something that can be matched by repeating talking points or misunderstood concepts.
Right, thank you, sir. Ms. McDuffie.
Thank you, Your Honor. So I am aware of 5 items that have been filed by Mr. Martin, I think after this case began to be pending in this court. And I'll just briefly address as to the formatting of those. I did notice all of them are handwritten. He does write a date on the top of each document, but then he usually signs off with a different date on the bottom of the document. So if it ever comes into play that there's an issue with the timing with respect to deadlines or anything like that, for my purposes, I'm just going by the date that it was received by the court, which is usually a third date that is different from the other 2. So the first document I'm aware of is titled Demand for the Return of My Motorcycle. That one was received by the court July 27th, or yes, I believe somewhere around there. I'm sorry, I'm not going to the dates aren't really important, so I'm not going to dwell on those. I'm just addressing these versus actually, I think, responding to them in detail. Defendants specifically ordered and demanded that the troopers from Michigan State Police return his motorcycle in this case. That is a request to police that was filed with the court. No response appears to be required or called for from the people, so I don't have anything to say about that. Next is the motion that was filed for the disqualification of the judge in this case. And I just wanted to point out a couple of things. First and foremost, as Mr. Martin pointed out, the court rule that relates to disqualification of judges, MCR 2.003, speaks to the exact procedure for that. In a single judge court, and actually the challenge judge here is the chief judge, the challenge judge is the person who decides this motion. So I don't have any argument to make as far as that, but I would point out there is a quote included in that particular motion that challenges this court's jurisdiction. And it cites a case from, what's that? Oh yes, Penhallow versus Doan's Administrators. That's a case from 1795. And the specific quote that was cited in that case to challenge this court's jurisdiction, it's a paragraph or so. It begins with something about, heavens, let me see. I want to make sure I have it correctly. I don't want to, It's not really important. In as much as every government is an artificial person, a creature of the mind only, all that stuff about artificial persons. I think Mr. Martin already made some references to that. I just want to make sure that Mr. Martin is aware that specific quote does not exist in that case whatsoever.
It is always interesting when they try to bring up real case law because it actually makes things easier to break down once you understand what the case was truly about. In this situation, the case being referenced is Murdoch versus Pennsylvania, and it has nothing to do with a general right to travel or avoiding laws. That case focused on First Amendment protections where individuals distributing religious materials door to door were being required to pay a licensing fee. The court ruled that applying that kind of tax to religious activity violated their constitutional rights because it placed a burden on free exercise and free speech. The key point is that the ruling was very specific to religious expression and does not translate into a broad loophole for ignoring traffic laws or other regulations. Taking a case out of context like that completely changes its meaning, and courts are quick to recognize when someone is misapplying precedent. It just shows that citing a case only helps if you actually understand what it says and how it applies to the situation at hand.
Quote that he used to challenge this court's jurisdiction doesn't exist anywhere at all, except for other cases where sovereign citizens have copied and pasted that non-existent case law, and they've been told the same by other courts. So apparently there's like a bank of things to be shared amongst people making this argument, just so he knows and everybody else out there knows. That does not exist. It's not a thing. It's nowhere in that case. That full text of that case can be Googled for free. You will not find that quote. The same is true of another case he cited, Keller versus Potomac Electric Power. That's from 1923. That case also does not include that quote, those words, or anything even slightly resembling that argument regarding the power he believes is lacking here due to municipal court status. But FYI, the Michigan District Court Act of 1968 did abolish most of the municipal courts. 4 of them are left that they did allow to remain: Grosse Pointe Farms, Grosse Pointe Park, and Grosse Pointe Woods. All of those are in Wayne County. We're in Washtenaw, so just so that Mr. Martin is aware, this is not a municipal court. It's a district court. Finally, as to the motion to disqualify, as I mentioned, that is for the judge to decide. But I might want to point out the manner in which he chooses to pursue that disqualification, including any comments or insults. For example, on page 9 of his motion, when he says that also Washington is not a real judge, but a clerk masquerading as a judge. Pursuing disqualification or recusal, or even a federal lawsuit, does not insulate you from the contempt powers of that very same court, should you choose to continue escalating that type of behavior. That's just the more you know for me. Third, next document that was filed from this court, it's titled Martin versus Mike. Plaintiff's response and objections to my return criminal complaint on Mike and the attached court letter that vaguely, unfairly stated filings does not comply with MCR 6.101 and 6.102. I didn't have a letter attached to that to refer to, but it looks like that is the court's rejection of an improper filing or format. I honestly have no idea who Mike is, but the people of the state of Michigan are not listed as a party in that filing, so I don't really have any response to that either. I can advise, though, that Mr. Martin mentioned earlier, and it's stated here, that the reference to this criminal complaint, because a defendant refers to himself as a plaintiff and titles something as a criminal complaint, it doesn't make either of those things true. So I'll direct Mr. Martin to the same court rule he actually cited in that filing, which is MCR 6.101. The prosecutor's approval or posting of security. A complaint may not be filed without a prosecutor's written approval endorsed on the complaint or attached to it, or unless security for cost is filed with the court. I just wanted to disabuse him of that notion that because he creates a criminal case, I guess in his mind and on paper, it doesn't mean that that exists in reality.
Got him!
So nothing more from that. The court's rejection of an improper filing really isn't my business, so no response from opposing counsel would apply to that. The last 2 things that were filed before the court are 2 demands. The court has already mentioned demands. I'm so sorry. It's a lot of talking happening here. I gotta refresh. 2 demands. 1 demand for default judgment and another demand for summary judgment. Both of these, I would have the same reaction to. The demand for summary judgment, summary disposition concerns parties to a civil action, and defendant is referring to civil procedure. not criminal procedure. There is no summary anything of that notion in criminal matters. Now, he made some references to Article 3 of the U.S. Constitution. That pertains to federal courts, appointment, tenure, Supreme Court justices, federal circuit and district judges. Those are Article 3 judges. Those are the ones nominated by the president, confirmed by the U.S. Senate. So this court is not controlled by Article 3 of the U.S. Constitution. But I think he knows that because he's citing Michigan court rules to sustain his argument for pretty much everything else. So that doesn't change here. Summary judgment is not a thing here. Default judgment. Now, that's not quite the way it works. I think he argued that because the prosecutor in court did not respond to the request to return his motorcycle for that first filing that I mentioned, that he should have a default judgment and he should automatically get what he's demanding because he didn't respond to it. Well, I'm responding right now, but that's not how it works either. Again, this is kind of a civil issue. There are cases where there are default judgments filed, but those are civil actions. We have traffic tickets that defendants fail to appear and get a default judgment. But if that were the case, I would have a default judgment of conviction for every criminal case where defendants fail to appear. People are on bench warrant status for 6 to 20 years at a time. I don't get automatic default convictions. So again, that's really not what's happening here. So those are the 5 things that I'm aware of. Now, finally, if it were true that, as Mr. Martin stated, that federal law trumps all state law, and that all state law and state courts are unconstitutional, the state court system would not exist, and the U.S. Supreme Court would not hear cases resulting from the need to interpret state law. Mr. Martin has yet to hear, as all of us do, of state constitutions and the power of the state courts that come from those being abolished. So his reference was correct, that there are people in this system who don't know any better and don't know what they're doing. I don't think present company is excluded from that.
At the end of the day, the legal system does not operate on individual consent, because if it did, there would be no consistent rule of law and everyone would be following their own version of it. Laws are applied based on jurisdiction and established statutes, not on whether someone personally agrees with them. If every person could opt in or out whenever they wanted, it would create total chaos with no uniform standards to enforce anything. That is why courts rely on objective legal frameworks rather than personal belief or preference. Whether someone agrees with a law or not does not change the fact that it still applies within that jurisdiction.
So on that note, Mr. Martin, if you want to continue without an attorney, you can, but I wouldn't recommend it. That's all from the people.
It's surprising you wouldn't recommend you're a prosecutor. But, anyway, well, I think that she said so much. I took some notes, but I couldn't take notes on everything. Hard to follow along with everything else. I think it's best to, same with me too. I say one thing, allow her to respond back. She says one thing, then allow me to respond to one instead of, you know what I mean? Like me saying a whole bunch, and then her saying a whole bunch, because it's hard to follow along for both of us, I think, harder. At least me, and for both, I think it's common sense. But all right, well, so I'm gonna respond now to the things I could follow along with. I took some notes, but I'm gonna need her to say again what I missed, and then I can respond one by one. Okay.
That's not how this is gonna work, sir.
That's
I
not
think
how.
To understand here, you
I have the right to that. What are you
you're not controlling this courtroom, sir. That's not how this works.
I'm speaking about what I have a right to do. I have a right to respond back. So
You're gonna get 5 minutes, and I'm gonna be done. So that is your opportunity. And after that, I'm gonna make my rulings. You got 5 minutes. I'm actually setting a timer.
All right. Again, I object to that again as being violates my due process right to the First Amendment. It's not supposed to be regulated by a certain time limit. My First Amendment right to say what I got to say, based on an arbitrary, unfair time limit.
Sir, in a minute, you're pushing towards being in contempt of court. You got 5 minutes. You can make your objection, which you've done. You got 5 minutes. Now please move forward.
Criminal. Okay, I want to object to that too, about what you said about contempt of court. Exercising the First Amendment is not contempt of court. It's nowhere close to that.
There's no First Amendment right in this courtroom, so you're a defendant. You need to actually do what is requested of you, and I'm giving you an opportunity to make your argument.
As to the criminal complaints, in response to what you said about that MCR, the refusal to act on my criminal complaints that I filed, because of MCR 6.101. And now, first of all, it violated my due process right, obviously, because they didn't mention a subsection of that rule. There's many subsections, okay? So I'm still left in the dark on what specific subsection it is. And all those apply to specific fact situations. So that was the first due process violation right there, just mentioning that too vaguely, general. Number two, but assuming it was based on not paying a fee or whatever, I think like she mentioned, or getting a prosecutor's approval. Okay, if it is for that reason, those reasons are unconstitutional and therefore it's invalid. That court rule. That's why I'm going to file a class action actually on the court rule. And I'm going to get that court rule and get up out of there because it's not legit. Why it's not legit? Because as I cited in there, I'm pretty sure I cited in there. If I didn't, I have to check my paperwork. But I'm pretty sure I cited in there, or I was waiting to respond back if I didn't already. But I'm gonna say right now that it violates the court rule on, the Michigan Constitution part that says that people have the right to prosecute their own cases. In Article 1, I forget the exact section. But I mentioned in my paper, in some future paperwork anyways, I know that if I didn't do it on this one, in the very first one, because I didn't know, what the hell subsection it was talking about. They didn't mention it, but I know I mentioned in some later ones sent to you guys. But anyway, so yeah. So it violates that right. And also, the U.S. Supreme Court case, Murdoch versus Pennsylvania. And I got the volume number, page, and all that. I think I cited to you guys before in the paperwork. It says that you cannot deny someone's constitutional rights by trying to make them pay money for something.